Welcome to the public meeting for the Foothill Village Subdivision Water Rights Adjudication. My name is Blake Bingham. I am the Assistant State Engineer who is responsible for the adjudication program in the Division of Water Rights. I know you all are come here under different ideas of what may happen here tonight, but and I understand that the notice you receive has a summons, had some legal jargon in it. May have been very scary, but I just want everyone to know first off the bat that this is not mandatory. If at any time you feel like maybe this doesn't apply to you, feel free to stand up and walk out. Just no big deal. We understand that a lot of people are just here just to know what's going on in their neighborhood, and some have varying levels of interest. But hopefully we'll be able to answer those questions. Hopefully you'll learn more, you'll know more after this meeting than you started out with. I heard someone saying it better be worth their time to come here and learn about this stuff. Hopefully I'll make it, I'll hit that target. Throughout the presentation, if there are questions that are maybe of a broad nature, maybe that apply generally speaking, please feel free to ask them. If they're more specific to your particular situation, I might ask you to hold off, and I will stay afterwards, and we can answer those questions you have that maybe have more specific pertinence to your own situation. So with that, I do want to introduce some of my crew. You've met maybe some of them, but first of all, Tamara Prue in the back here. Say hi, Tamara. She's my team leader. She'll be the one responsible for this particular subdivision, so she's going to be kind of conducting the boots on the ground operations. Gary Brimley is my assistant in the adjudication section. Our contact information will be on the last slide of this presentation, as well as this presentation is being recorded and will be available off of a link on our website shortly, maybe tomorrow or the following day, once we get it processed. We also have Kent Jones, who is the state engineer, my boss. He's there in the back. He is the state engineer, so he manages and directs this process. Ultimately, I manage this process on his behalf. And then we have from the Attorney General's office, Melissa Reynolds, who represents the state engineer, as well as Allie. And Allie, I've forgotten your last name already. Romaldo, that's right. She is our paralegal for the Attorney General's office, and I think that's pretty much it. Oh, we got Jeffrey King as well as another boots on the ground guy. So, again, as we go throughout this presentation, please feel free to ask your questions. This is the agenda for tonight's presentation. We'll do an overview. We'll talk about the proposed determination process, what that entails, and then some of the significant issues and anticipated timelines. The presentation takes about 45 minutes in total, depending on how many questions and how in-depth we get into those questions. But again, if you have questions, I know I have it there at the end, ask them throughout. So I generally like to start off, there's varying levels of understanding of the concept of adjudication, but even varying degrees of understanding with respect to what is a water right. So for those of you unfamiliar with what a water right is, it's really the right to remove water or divert water from a natural body of water, such as a stream or a well, the underground aquifer, and then beneficially use it. The concept of a water right has typically 5 different aspects of it. You have the nature of beneficial use, or in other words, what is it being used for? Is it being used for irrigation? Is it being used for your domestic properties? Is it being used to water stock? There's a priority date, and the priority date is in essence when that water was first put to beneficial use, and that ties into the system under which most of the West operates, this doctrine of prior appropriation. In essence, the first in time is the first in right. It's kind of like a mining claim, so those who appropriated their waters earlier get seniority with respect to the diversion of those waters. It has a defined quantity of water, and how we measure that is either a flow rate or an annual diversion volume. The flow rate we measure in cubic feet per second, often abbreviated as CFS. The volume, the annual diversion volume, is in an acre foot. So if you can imagine a property that is an acre in size and then 1 foot in depth, that is the volume of water over a year. So when we say acre feet per year, that is sometimes how these water rights are quantified. They have a specified point of diversion, and all that really is where the water is being diverted out of the stream. For underground sources, that's the well, where the water is coming out of the well. It may be a spring. There's a couple different types of points of diversion. And then it has a specified place of use, and that's where the water is being put to use. For irrigation, it would be specified it's in this particular section of the public land survey. It might be your home, it might be for stock watering, it might be along a certain stream. So these are the kind of the different characteristics that water rights have. So many of you, we get a lot of calls, well, I don't know if I have a water right. So we kind of help people understand what might be an evidence of a water right. Often wells that are located on your property are evidence that there may be a water right associated with those wells. And then also irrigation ditches can sometimes indicate the existence of a water right. For any diversion of water in the state of Utah, there should be a water right associated with that. Now, whether that water right belongs to you or it belongs to the municipality and they simply provide that water to you, that's kind of sometimes where the confusion creeps in, as well as irrigation companies and those types of organizations that provide water in return for a share ownership in their company. So what a water right is not, as I mentioned, it's not a share in an irrigation company. In that case, the irrigation company owns the water rights. You simply own a share in that company, and they divert the water to you based on that share. I'm not familiar with, there may be some irrigation companies coverage in here. More likely, sometimes Salt Lake City does an exchange, and they provide irrigation water is what we've kind of seen in this area. And it's not a connection to a public water supplier. So it's not the water that comes in through your meter that you pay to Salt Lake Public Utilities or anything along those lines. Now, they do own water rights, and they are participating. Salt Lake City does participate in this process, but that water is already accounted for under those water rights. So it's not the water coming in through your meter. So when I talk about adjudication, it's really hard to grasp the concept of why we're doing this without giving some historical context. So I'm going to kind of provide some of that. Hopefully, you've probably heard a lot of this, but some of it may be news to you. We know the story that in 1847, the Mormon pioneers entered the valley, and they began diverting waters from City Creek in order to soften up the ground to get some late season crops. They then built their shopping mall on top of it. In 1848, Brigham Young declared that there shall be no private ownership of the streams that come out of the canyons. They belong to the people, all the people. And that's kind of remained the binding concept, the underpinning of the concept of water rights in Utah. And that the water is not owned by the state of Utah. It's actually owned by the public. The state of Utah administers those rights that are owned by the public, though. From 1847 to 1850, what we now know is Utah went through a transition. It was once part of the country of Mexico, then it went into this kind of quasi-ecclesiastical state of Deseret, and then it finally into the territory of Utah. And the takeaway from that is that Mormon pioneers or whoever was here, they diverted water, right? But there's no system for establishing those water rights. So even though the political boundaries shifted, the diversion remained pretty constant. It was diverted by the Mormon pioneers on a communal basis, typically to meet the immediate needs of those settlers. The doctrine of priority evolved through that concept. You had those groups that first settled along the Wasatch Front and different parts of the West who started digging ditches and diverting water, and they became the senior right holders on those particular diversions. And then as subsequent settlers came in, they were given secondary rights. So the primary settlers got the first cut of the water, and then those secondary settlers got the secondary. So that concept of primary rights and secondary rights later commingled with this concept of a mining claim, that concept of pure priority. And that's kind of what we have today. Conflicts were settled through ecclesiastical channels. You had bishops' courts for kind of local disputes, and then you had the high councils, which were kind of like an appellate court. So if you didn't like what the bishop had to say, you go complain to the high council, and the high council would say, all right, well, here, we'll figure this out. And so that's how it was ran, because there was no other kind of structure in place in order to divert these waters and to settle these conflicts. So it was just kind of that power vacuum that was filled by the church at the time. Well, as we transitioned into the territorial era, there was an attempt in 1852 for the first territorial legislative assembly. They passed a law that gave the authority to the county court for the diverting and recording of water rights. And that was great in theory, right? But in truth, the county court were the same people that were on the high council and the bishopric. So it really didn't do much, and for the most part, it wasn't really honored, with maybe the exception within the Salt Lake Valley. In 1877, the Desert Land Act was passed by the United States Congress in an effort to reclaim some of this arid and semi-arid public lands. The real interesting concept or reason why I bring that up is because back east, if you had a water running next to your property, then you automatically had a right. It's called a riparian right. Well, in the west, as a result of this act, that act severed the water from the land, meaning you could divert the water from where it was originally running and carry it and move it and place it on to use somewhere else. So in essence, you didn't have to be the property owner to have a water right. You could sever title from the land. But it also delegated authority to the individual states and territories to administer water rights. And so that's kind of at the time it was a novel concept, because if you think about it, the United States, through the patent office, through the government land office, they're the ones responsible for issuing patents for land. So if you wanted to homestead something, you had to go to the federal government and get a patent, and then you had to homestead it and prove that you had homesteaded it. Well, this is different because now you can just go to your state government and they can give you a water right. So it is a interesting fork in the road that is played out and will play into what we're going to discuss here in a little bit with respect to adjudication. In 1880, due to the failure for the courts to enforce that 1852 act, they abolished it and appointed these county selectmen who were kind of ex officio water commissioners, but they were pretty much ignored, and whatever certificates they issued were ignored. And again, all but a few counties really participated in that. As a result of that, confusion continued to persist. Despite the best efforts of the territorial legislature or the LDS Church. And the church continued to administer and decree water rights. A great example of that is the 1879 High Council decision on the Spanish Fork River, which is continued to shape the way that water is diverted to this day. So that original High Council decision established the main companies that were awarded rights, and those are the same companies that have those rights to this day. So it's been an evolution, and again, the LDS Church kind of filled that vacuum. So in 1896, Utah becomes a state, and there was a lot of controversy when this happened over the concept of water rights. There was some concerns that the state of Utah was going to come in and just grab everyone's water rights and say you're not allowed to divert anymore. All the waters now belong to us. And so, rather than address the issue and come up with a comprehensive water law, they decided just to kind of punt. Right? They just kicked it downfield and say we'll deal with it later. The only thing we're going to do now is we're going to put something in the Constitution that says that if you've had a right to use water, you're good to go from here on out. And so, in Article 17 in the Utah Constitution, it says all existing rights to the use of any of the waters in this state for any useful or beneficial purpose are hereby recognized and confirmed, meaning if you've used water, you can continue to use water. And they just left it because it was too controversial to deal with at that time. In 1897, the legislature finally realized that, hey, there's kind of we got to figure out what the availability of water really is throughout the state. And so they came up with the Office of the State Engineer, which is what this Division of Water Rights is today. So when we say the Office of the State Engineer, it's kind of a historical name for the Division of Water Rights. He was tasked with conducting hydrographic surveys, which in essence going and mapping where these streams are at, how much flow was coming out of them. But appropriations were still, when I say appropriations, getting new water rights were still done in the old-fashioned way where you go stake your claim, and then you go file it at the county courthouse and the county post office. But those were, again, largely ignored, and you see Willard Young, with a name like Young, you can probably guess who his father was. In 1902, the United States Reclamation Service was established. It's what we now know as the Bureau of Reclamation. And their mission is to reclaim the West, right, by building huge irrigation projects, large-scale reservoirs throughout the West that people can then use that water to irrigate those lands and reclaim it. However, they were really reluctant to do any of that in any state or territory that didn't have a comprehensive way of figuring out what water rights already existed. And Utah fell into that category. It was pretty much just open season. There was no comprehensive way to appropriate water. You just kind of had to divert it and stake your claim. And so they encouraged states to adopt these comprehensive water laws. And it's no consequence, it's no coincidence that in 1903 Utah did just that. They enacted their first comprehensive water law. It called for the recording of all existing water rights and the adjudication of the rights by the court. So in essence, they're saying, all right, court, this is your job. Figure it out. But they didn't provide any funding for the court to do that. And the court really didn't know how to tackle that, right? Unless there's a pending litigation, they don't really go out and initiate litigation. And so there wasn't really a good mechanism for figuring out what all these existing rights were and how they should be administered. Well, in 1919, the legislature finally came around to the conclusion that, hey, what we'll do is we'll have the state engineer go out and figure out what these water rights should look like and then make a recommendation to the court that the court can then take and issue a decree on. And that recommendation is called a proposed determination. So when I use that term, just think of official recommendation from the state engineer. And that's largely what we do to this day. In 1935, so prior to 1935, you didn't need a water right to drill a well. They kind of figured that surface waters are what you need to appropriate. Groundwater was just free chicken or something. You can just drill a well, it's free water, no worries, not connected to surface sources. Well, they finally got wise and realized that in 1935 that, hey, these things really do communicate, and they communicate very well. And so they came up and said, well, in 1935, you have to have a water right to drill a well. But if you had a well prior to 1935, you're grandfathered in, similar to the concept of if you diverted water prior to 1903, you're grandfathered in. And we'll talk a little bit more about those. So prior to the enactment of that comprehensive water law in 1903 and the subsequent change in 1919, water rights kind of fell into a few different categories. You had those that were decreed by ecclesiastical leaders. You had claims that were filed for record at the county. They'd go stake their claim, then go take their claim to the county courthouse or the county recorder. They had those rights that were decreed by a court, pretty much typically involving limited parties. So if someone was suing someone else, they'd come before the court, and court would say, all right, you own this much water, you own this much water. But they weren't really addressing anyone else's water on that same stream, so it wasn't really comprehensive. You had those that were just contracts or agreements between two different parties. They didn't really have anything else to do. They just said, well, I'll exchange my water and you give me this water type of thing. And then you had those claims that were never manifested itself on any type of record. These are the people maybe living up in the mountains or just lazy or I don't know, just did not bothered, right? And they just said, well, I'm diverting water, I'm using it, I don't really need to file a claim, no one's really pressing me on it, so I'm just going to continue to divert that water. And these are what we now know as diligence claims, or pre-statutory rights. So before 1903, remember you didn't need a water right? These are those people. Same thing for the groundwater rights prior to 1935. So as a result of the concept of water law, there's typically no public record. There certainly wasn't any consolidated public record. And since there was no public record, there was over-appropriation of the streams. And because the streams were over-appropriated, they weren't defined, there was a lot of controversy. In his 1901-02 biennial report, the first state engineer A.F. Dormus made the following observation. He said the determination of existing rights, meaning those rights that were already being used, appears to be of first importance. This is not only necessary to pacify present contention, but to prevent future conflicts and encourage further progress. There can be no safe basis for future work before existing rights are known and made of public record. So that was a great theory, right? Hey, we're going to find out all these water rights, these existing water rights are first before we appropriate new ones. Then they realized how hard that really is and just decided, well, we're just going to appropriate and we'll figure this out as we go. So that's kind of where we're at today. We're still figuring these existing rights out. We're appropriating. We have these two parallel tracks of appropriation and adjudication underway within the Division of Water Rights to this day and throughout the state of Utah. So what is a general stream adjudication? Well, as the name implies, it's an action in court. It's actually an action in state district court, which is significant rather than federal district court or federal court. It binds all water users, including the state engineer, within the respective drainage. That's the title of code that it's governed by if you ever want to put yourself to sleep at night. The first general stream adjudications took place back in the 20s. You recall 1919 was when they first came up with the concept of the proposed determination. So not too many years after that, they started doing that. And so really, as you look at these colored shapes on the state of Utah map, these are all different general adjudications. Now, when we talk about the Utah Lake Jordan River general adjudication, which is what this subdivision is part of, so we have the big Utah Lake Jordan River general adjudication. That's that big purple blob right here. Okay, so it's a big bite of Utah, and it's a highly densely populated bite of Utah, and it goes all the way up into the headwaters of the Provo. Goes down to Goshen and up in northern reaches of Salt Lake to the Great Salt Lake. So it's a big area and it has a lot of people in it. And so what we do is we split it up into subdivisions. So the Foothill Village is just one subdivision of this bigger general adjudication, the Utah Lake Jordan River general adjudication. Now, there have been some adjudications which have been completed, including the Weber River and the Sevier River. The Virgin River was completed, but they decided they wanted to do it again, so they reopened it back in 1980. But the Utah Lake Jordan River general adjudication is actually commenced in 1936 and has been going on ever since. So we're just barely getting around to your neck of the woods, if you can believe it. So why do we conduct general adjudications? First of all, we want to bring all claims onto the permanent record. You remember this guy. He's the one diverting water, doesn't really want to file a claim. We want to get those pre-statutory claims, and so we call those surface rights that are diverted prior to 1903 diligence claims, and we call those water rights that were diverted prior to 1935 underground water claims. In essence, you have groundwater and surface water, and they have different grandfathering dates. So we want to bring those onto the claim, onto the record, so that we have a consolidated record that people can go to and see, hey, what's the status of this particular source. The next claim we want to bring on, this is a little bit more tricky, it's Federal Reserve rights. Now, this is a kind of an interesting concept. Prior to the turn of the century, there was a Fort Belknap Indian reservation, and they wanted to appropriate water. This is up in Montana, North Dakota. They wanted to appropriate water, and the state said, sorry, you're out of luck. All the settlers around you have appropriated all the water of this particular river. And they said, well, that's not fair. The U.S. government's forced us to come to this reservation, and now you're saying we can't do what we need to do here? So they took them to court, and the Supreme Court ruled that by the virtue of the fact that Congress had set aside this reservation, that there was a implied water right or a reserved water right associated with that reservation that was equal in priority date to the date of the reservation. Now, why is that significant to us? Well, we do have some Indian reservations in the state of Utah, but this concept of federal reserve rights has been applied to other types of federal reservations, such as Forest Service reservations, national parks, national monuments. So those parcels of land that have been reserved from the public domain could have a Federal Reserve water right. The problem is that the federal government enjoys federal sovereign immunity, right? You can't sue them unless they let you sue them, which sounds screwy, right? Well, there was a senator from Nevada back in 1950s, Senator McCarran, who said, hey, well, we've got to figure out, if we ever want to have a safe basis for appropriating our rights, we've got to figure out what these Federal Reserve rights would be, because the federal government was just saying, we're not worried about quantifying, we just know they're there, and we'll let you know how much it is when we decide to use it. And it was really hard for states to appropriate waters based on this unknown shadow of Federal Reserve water rights. And so Senator McCarran ran a bill called the McCarran Amendment, which waives the federal sovereign immunity with respect to general water rights, general adjudications. Not only does it do that, so that means that the state of Utah can take the federal government, to court without them waiving their own immunity and force them to quantify what those water rights are. In fact, they can even do it in state district court. So it's pretty unique in the concept to have the federal government bound by a state district court. It's a unique concept that is, as far as I'm aware, unique to general water rights adjudications. So those are some of those claims that we don't know what they are until we figure them out in the general adjudication. And in Foothill Village, there is Forest Service ground. You know, the drainage goes all the way up into Forest Service land. And I'd have to look at, they did make, back in the 80s, I think they made a giant claim and listed all the water rights that they lay claim to. So as part of this adjudication, we have to meet with the Forest Service and say, all right, quantify your claims. And that's a little bit more laborious process, but it is ongoing. Another reason why we do this is to prevent a multiplicity of suits. We don't want people suing each other over water rights. We just want to kind of get it once and done. We want to remove or reduce those rights which have been abandoned or wholly forfeited through non-use. So this is probably one of the more controversial concepts in Western water law. And it's not unique to Utah. This is pretty much throughout the arid West. It's a use it or lose it. And so the reason for that is they wanted to make sure that there wasn't speculation, that people wouldn't acquire these water rights and then hold on to them for, you know, monopoly purposes and require people to come and purchase them from them. So as a result of that, they implemented this law that says if you don't use your water right for a period of 7 years or more, it's subject to forfeiture, meaning you can lose it. And that's pretty common, like I said, throughout the arid West. Utah is one of those states that does that. And it depends on the state you go to. That period may change from, I think in Colorado, it may be 10 years. It used to be 5 years in Utah, and they changed it to 7 years. So that's a concept that I think probably a lot of people find counterintuitive. But if you think about it, if you're not using that water, someone should be using it somewhere. And so that was the reason why they wanted to have that law come into effect. Lastly, we want to obtain final comprehensive decrees on all the water rights within the respective drainage. So I'm just going to cover the adjudication process in broad sweeps here. Yes, sir.
You have one of those wells that has not been used for like 40 years.
Did you say 40? Okay. So his question is, and this is the pretty common question, if you have a well that you haven't used for several years, we'll just say over 7 years, can you still use it? So throughout this process, what's going to eventually happen if you want to claim a right to that well, you'll file a claim on it, right? And then we'll come out and we'll evaluate. I'm going to get to this process more depth here. I'm just giving you some context. And when we come out, and if we observe that that well is being used, we don't really go into CSI water rights mode and try to figure out if it just barely came into use or not. We want people to use their water. So, you know, this is kind of the big takeaway, you know, stomp my foot so that you guys realize an interesting point to remember is when we come out to evaluate your water rights, make sure your wells are functioning and that you're using your water. So yes, I'm just going to repeat what your statement so for the benefit of the crowd. He's saying, so if I want to use it, I better get it going, and so you can come out and evaluate. Yes, that is what I'm trying to imply, ever so subtly. So let's just say, if you have a well and you want to claim that well, again, put it to beneficial use. The state engineer received no benefit out of recommending these rights to be forfeited. We actually prefer if people are informed on their water rights and put them to use and are using that water, definitely. So it's oh, sorry, yes.
So this water source, you know, the groundwater, the wells and all that kind of stuff, but then the surface water. I know, you know, a few years back, a bunch of us participated in being able to get water rights to like the rainwater off our roof for barrel collection, water collection systems. What does that have to do with the natural source? Because I couldn't find it anywhere.
That's a great question. So her question is about rainwater harvesting, okay? And that's kind of a different concept. You don't need a water right to harvest rainwater, okay? Utah legislature passed a bill a few years back that permitted people to harvest water right up to a certain number of gallons, depending on whether it was an underground container or above ground container. So that's not really a right. There's a process to go through. I think the process is you have to register with the state engineer on their website and just let them know, hey, I'm doing this. So that's different than the concept of a water right, and they're easily conflatable. But so if you're harvesting rainwater, there's a different prescribed way to do that, and you can do that at any time. You can stop doing it and then restart doing it. It's not the same concept as a water right, but the legislature, against our wishes, stuck us with monitoring that. Ultimately, yeah. So I won't get into that, but you can register to harvest rainwater on our website. It has nothing to do with this adjudication process, and that's not something you would file a claim on. Does that make sense? Okay. Any other questions? And if I'm not watching over here, just yell at me and I'll get to you. Sometimes I favor this side a little bit. All right, so the adjudication process is kind of a three-phase process. First phase is kind of what we're doing right now. We have the petition. That's what happened in 1936. It was actually, this particular general adjudication was instigated by Salt Lake City, who in 1936 there was an amazing drought throughout the western United States. And there were a lot of people diverting water out of the Jordan River and using it. And Salt Lake City didn't appreciate that very much, so they filed suit against like 2,000 people. And they took him to court, and the court said, no, you can't do that. You've got to go into a general adjudication because this Jordan River ties into the Utah Lake, and it has ties to other water sources, so it really needs to be a basin-wide. And so that's what instigated the Utah Lake Jordan River general adjudication. The notice, we published notice for the Foothill Village Subdivision in the newspaper. We sent the summons. That's what you received that indicated that we were having this public meeting tonight. And then that public meeting is what we're doing right now. So this is kind of where the end of phase one of this process. The next phase, and again, I'll go into these steps a little bit more in depth here in a second, involves filing claims, having us come out and filing claims. Any claims that are, or any water rights that are not claimed go on this list of unclaimed rights, which means, so there are water rights of record. So meaning we have water rights that are numbered in this Foothill Village Subdivision. I think we have around 37. So it's not very many. So we have records of those on our division. And if one of those rights or some of those rights don't have a claim filed on them, they go on this list of unclaimed rights. And then there's a 90-day period. If people don't object to that list, then those rights, by virtue of no one filing a claim, they just become abandoned. The court decrees those as abandoned, meaning no one's shown an interest in these, no one's using them, so we're going to wipe them off our books just so that we're tracking actual water use. Yes, sir? His question is, where do we find out where that list is? So when we get to this point, we will send notice to the same people that received notice in the summons. The list of unclaimed rights is available, and we will provide a web link where to access it. Any other questions on that? Yes, ma'am.
Just back when we got the letters, we got like 2 letters in the same mailing.
Okay.
And one was, of course, for this September 20th.
Mm-hmm.
But the other one that it shows on the order of the court is stated below, June 10th, 2016. So there were 2 different type of.
So yeah, so you have it's not super intuitive. So her question is, in the letter you received, there's 2 different orders, right? There's a summons and there's a court order. The court order was necessary for us in order to send summons out by mail. And so that's why that is included. So the order is old. It's applicable to all these other subdivisions we're doing. So we send the summons out with that court order that allows us to send it out by a regular mail. So that's why that has an old date on it. That's just the court order. Yep. Yes, ma'am. Her question would any of those unclaimed rights be available to purchase? You could purchase whatever you want. Now, is it worth anything? Probably not. I wouldn't recommend buying it. I mean, you wouldn't purchase them from us. These rights are owned by someone, and they go on this list. So bottom line is, it's probably not what you want to spend your money on. It's because they would be of zero value. Well, once they go on this list of unclaimed rights, and they become abandoned, then they're of zero value because they wouldn't be honored as a water right. No, it's following the 90 days. So after the list comes out, there's a 90-day window for people to file an objection saying, no, that is my right. I intended to file a claim, and here's my claim. And again, I'm going to get into this process a little bit more in depth. So they have 90 days after that list comes out to articulate that argument before the court. Not before us, it goes to the court, and then we have an opportunity to answer that. But again, if it's simply, hey, I'm interested in purchasing that right, I'm going to file an objection and try to obtain it, we would probably oppose that, and we would probably litigate that. Certainly, you can contact whomever you'd like to contact and purchase whatever you'd like to purchase. Just be aware, do your due diligence, and I would recommend seeking competent legal counsel in figuring out whether that water right is valid or not. That's all No, you can. Water rights are transferable. You can buy and sell all day, but whether that water right is going to be subject to forfeiture in the future because it hasn't been used, or whether it goes on this list of unclaimed rights and becomes abandoned, that's what I'm saying. Is there's always that possibility. So it's kind of a buyer beware. Make sure you do your due diligence before you exchange any monies. Yes, ma'am. So your question is, how would someone know to call someone and in? Are these lists public? You mean like the list of unclaimed rights? So her question is, are these lists public? Yes, they're public. You just need to know where to find them. And after this meeting, I'm happy to stick around and show you an interface that shows the boundaries of these subdivisions and shows all the water rights within those boundaries. So for those who are interested in pursuing that, go for it, I suppose. We don't deal with purchasing and selling of water rights at the division. We simply monitor ownership and update our records and the beneficial use of those rights and the administration of those rights. Yes, sir.
So we talked to some of our neighbors, and they didn't get a summons to come today. Does that mean, like, if we got a summons, so we have some on the record that we have a water right or something?
It's a good question. So his question was, he talked to his neighbors, they didn't receive a summons. Does the fact that we received a summons mean that we have a potential water right or not? So let me give you an idea. So how we developed this mailing list. So we sent out this summons to about 10,000 people. And how we do it is we get that boundary that you received in your summons, and we go to the county recorder and say, give us the property owners of all addresses of all the people in this boundary. And so they send that to us. So why your neighbors didn't receive the summons, I can think of maybe a couple reasons. They're not the owner of the property. They're outside of the boundary. They didn't pick up their mail. I'm not sure. But we send it. So statutorily, we're not really even obligated to do that. We do that because we want the public to be apprised of this. Statute by statute, we send it out to water right owners of record, which would be 37 people, right? But we send it out to all property owners because there may be people with wells who don't have a water right on record, and there may be other people who are interested in this process. And so that's why we, instead of going 37, we go to 10,000, just out of an abundance of caution to make sure that the public is apprised of this. So I'm not sure why your neighbor did or did not. I know I did receive a call from a lady who had the same question, and it turns out that the property where her parents lived was in a trust, and that trust had mail going to an office location. And so if the person's not the owner of that property and it's just renting, they wouldn't have received it. It may have gone to wherever the owner receives mail for that particular parcel. Yes, ma'am. I'll get to you.
What about water rights that were taken away because the water was diverted for another use by either the city or the state?
So your question is, what about water rights that were taken away or could be subject to forfeiture because water was diverted by someone else? There probably needs to be a little bit more definition to that question because there's a couple different scenarios that might fit in. The answer would be different. And so if you're talking about, I'm diverting off this stream, there's a senior right above me, and they're diverting all of the stream based on their priority, therefore the water is not available for my water right, then that water right is protected. If it's not hydrologically available on a surface source, it's protected. Now, if you're saying, I haven't been able to divert on this water, so I just stopped diverting, my diversion structure is completely destroyed, and I haven't even tried to do anything about it or maintain it, we start to kind of get into a gray area. But water that's not hydrologically available because a senior priority appropriator has been diverting it is protected. Now, groundwater is a little bit different. So if you're saying I have a well, but because so many other wells have been plugged into the ground around me, now I can't because the water table has dropped, that is not. The court Utah Supreme Court has established a case precedent that people are to seek after their water in groundwater. So you just have to go deeper in your well, and that's how you protect your right. Okay. So that's why I say it may depend on the scenario, and if you have a specific one, we can talk about that after. Let me go over here.
You're talking about 37 people of record who have these water rights. Does that include the public spaces or company corporate spaces? For example, Bonneville Golf Course is on this space.
Mm-hmm.
So I'm sure the city has some water right there. Are they part of that?
So your question is, do those 37 people or entities include water rights on public spaces such as Bonneville Golf Course? And yes. So Salt Lake City has been a participant in several of these subdivisions, and if they had a well in that area, if they had a well in that area, they would participate in this subdivision as well. But yes, to answer your question succinctly, yes, it does. Okay, I'm going to continue on through this slide. Let me get through this slide, and then I'll answer another round of questions. Otherwise, we just got to keep it flowing, right? We'll run out of YouTube space, and they won't let us air it. So after we get through that list of unclaimed rights, we'll send out notice. We'll do another public meeting, answer questions on the list of unclaimed rights. And then, if people object to that, say, no, that's our right, file a claim, we're pretty generally lax about that. That's fine. We want people to file claims. But then the court will establish a decree on that list saying that those rights that remain on the list have been abandoned. Okay. Following that, during that process, we'll also be evaluating those claims that were filed. So you'll file a claim. Boots on the ground staff will come out, take a look at it, look at the well, look at the beneficial use, make sure it makes sense, and then take your claim and create a recommendation and include that in the proposed determination. That proposed determination is mailed to people who have filed claims, so it won't be the same group. So that recommendation only goes to people who have filed claims, and they'll have 90 days to file an objection on that proposed determination, have another public meeting, and then the court will issue a decree on that. So let's talk about filing your water users claim. So after this meeting, in a week or two, and I don't remember the exact date, Tamara, what was the date we're going to send out notice to submit claims on this? October 13th. We are going to send out notice to file claims. So we will send that both to water right owners as well as property owners. So the same people who receive the summons will receive this notice to file a claim. In that notice, there will be either a blank claim. Well, we'll also publish that notice in the newspaper just to spread it as far as we can, right? Get everyone in. So for those who are property owners, we will send a blank water users claim so that you can fill it out. Now, we don't expect you to really know, unless you've been involved in this process before, how to fill that out. And so we welcome you guys coming in or calling us up and asking us how you can file that claim and what needs to go in those different fields. For those who are water right owners of record, they'll receive a claim that's already filled out with the information that we have on our database. And if they feel like they need to amend that, they can simply line things out or make corrections to it and then file that. And you file that either with the state engineer or you file that with the state district court, the third district court. You have 90 days from the time that notice is mailed, so October 13th, in which to file that claim. Otherwise, you'll either be barred if it's a new claim, or it will go on the list of unclaimed rights if it's a claim of record. Okay? You can ask for a 30-day extension. All you need to do, we have a form on our website, or you can simply email me, and my email address will be at the end of this, or email anyone here and they'll get it to me. And by virtue of the fact that you ask for an extension, as long as that extension is requested prior to the expiration of that 90 days, that'll just give you another 30 days, so 120 days if you need more time. Once we receive the claim, hopefully the claim has some contact information, hopefully a good phone number or an email address so our team can contact you and find out a good time to come and look at this claim so we don't surprise you. Or that we really want to do that with you present so that you can show us how this water right is used. So you can show us the well, you can delineate the ground that's being irrigated or the house that's being used. So our team will come out, they'll evaluate the claim, they'll map any irrigation, they'll map where the point of diversion is, and then they will use that claim for the basis of the proposed determination, which we'll get into. Now, you recall the list of unclaimed rights, which is kind of where we got hung up last time. The list of unclaimed rights is for those 37 rights of record that if someone fails to file a claim, the owner of record or a claimant fails to file a claim, they'll go on this list of unclaimed rights. That will get sent out to everyone here, the same distribution. We'll hold a public meeting, and then people have 90 days to file an objection. But they've got to file their objection and a water user's claim with the district court. They don't do that to the state engineer because now we're in the legal phase of this. So any objection proceedings need to be done before the district court. And it doesn't have to be anything super immaculate. It's simply make sure you have the basics information so that when the court has it, they know what case it needs to go to, and that case number will be on your claim, as well as I think it's on the summons as well. Once those objections are filed, the state engineer has to have them resolved one way or another. Either the state engineer will simply, the court will say, yes, we're going to allow this objection, and we're going to allow this person's claim to be evaluated, or the court will dismiss the objection. Either way, the objection has to be resolved before the court can issue a decree on that list of unclaimed rights, decreeing that those rights are abandoned, and then they will also, at that point, as part of that decree, cut off anyone's opportunity to file a diligence claim. You remember those claims that were never filed, and we said, hey, you're good to go, you're grandfathered in? Well, this is like the last chance for those claims to be filed, because following this decree, you can't do that anymore. So in essence, they bar anyone from asserting new diligence claims or underground water claims at that point. The proposed determination is kind of similar to the list of unclaimed rights as far as sequence goes. We issue a proposed determination, we file it with the court, we send notice to those who have filed a claim or those water right owners of record. So this will be a little bit different. So as opposed to sending out 10,000 notices, now we're just focusing in on a targeted group of people who have come forward and want to participate, right? And so we'll send out notice of the proposed determination with a web link of how to access it, as well as the hydrographic survey map associated with it. We'll have a public meeting. People have 90 days to file an objection to the proposed determination. Again, we have to resolve those objections before we can get a decree on the proposed determination. And that's kind of the ultimate objective of this, is to get a decree on the recommendation of the state engineer for this subdivision. And then we move on now to a new bite of the adjudication. So here's the Foothill Village proposed determination boundary. You can notice it's maybe a little bit hard to see. You might have to squint a little bit. But this map's also outside, hanging on the wall. You see all these green dots. Those are locations for water rights that we have record of within this boundary. Okay? And like I said, we have about, 31 water rights of record. Most of them are underground water rights associated with wells. And again, we've notified about 10,315 is on our mailing list. Yes, sir.
Let's say a year from now, you want to build a well on your property.
It's a good question. So his question is that, a year from now, I want to well my property. How do I do? What do I need to do? Well, the Salt Lake Valley has long been over appropriated. We have more than double enough. We have more paper water than we have actual wet water. So they closed it to new appropriations long ago. So the way to acquire a water right for a well, is to purchase it from somebody else and then file what's called a change application. So you'd move it from that well over to your well. Now there are some restrictions depending on where this water is coming from. Obviously, it has to be hydrologically connected for a change application to make sense. But the regional office, Utah Lake Jordan River Regional Office, are the ones that look at those applications and ultimately approve or reject them. Yes, ma'am.
So if you don't have a well, then this meeting is really null and void because you can't really, you're not using your water rights, so they're going to disappear. Yeah, what's the process that you're...
So, yeah, our question is, if you don't have a well, then this meeting may be moot because if you didn't have a water item, it's going to disappear because you haven't been using it. And the succinct answer is yes, I suppose, other than for informational purposes, I suppose. But yeah, as a matter of fact, if you don't have a well, if you don't have a water right, then this process, you don't really need to participate in it. And we tried to make that clear on the cover letter. I know we probably need to sharpen our pencils a little bit and maybe refine that so that's a little bit more clear. We've tried to. But yeah, in essence, if you don't have a claim or you have no basis for a claim, there's no need to participate or about this in the future. Yes, ma'am. Hydrologically connected. The definition of hydrologically connected, and I'm not going to rely on Webster's dictionary, but just I'm going to break it down Barney style. So the water communicates with each other, right? So if you have groundwater over here and you have groundwater over here, at some point they're tied together. You can have a hydrologic connection between surface waters and groundwaters, but the obvious example of what may not be hydrologically connected is the Colorado River and Jordan River. It's hard to say that those are truly hydrologically connected. I know in the big scheme of things, they probably are. But, in a basin-wide, they probably aren't. So there are some restrictions based on that, and as well as in how groundwater is moved from point to point in the Salt Lake Valley that has been defined by the state engineer policy in that region. So there's some other restrictions, and we just recommend that you get with a competent engineer or someone who's informed about water rights to kind of navigate that, help you navigate that process. There's another question over here. Yes, sir.
Clarification on the well. If you wanted to put a well on your property, you don't currently have a water right you know of, you have to obtain one from another water right holder from anywhere in that area, or what's the process of going to the well?
So his question is similar to the one was asked generally just now. If you want to get a new well, what's the process? So the first thing you need to do is acquire a water right. But what I do is do due diligence and ensure that the water right you're going to acquire is valid, has been used, can be moved based on the policies of that region. And then once you file a change application, that change application gets sent and notice to everyone in the newspaper. People have an opportunity to protest it. And then if it's approved, then you got an approved change application on a well. You can contact a well driller, and he's going to say, all right, what's your water right number that this well is being drilled under? And you say, da-da-da-da-da. And he said, all right, Roger got it. And he drills the well.
Back to step one.
Okay.
I go to Google and I search for anybody want to sell me a water right?
Yeah, so there's actually a water right market website that has nothing to do with us, okay? So I'm going to abolish any kind of liability with that statement. I think it's waterrightsexchange.com or something like that. But there's a market for it. And if you Google water rights for sale, Utah, I guarantee you'll come up. They sell them on KSL.com as well. Yeah, I mean, so water rights in the valley are a lot of money, right? So there's a lot of money at stake, and when there's a lot of money at stake, there's always the tendency for people to try to take advantage of other people. So I just say, be careful, be wise when you're looking for these water rights. Yes, sir. So he says, there are springs in the area. What can I tell you guys about springs and property rights? if those springs don't have a diversion on them and they haven't been beneficially used, there's really no water right associated with it. What's happening is those springs are running down river and being used elsewhere by some other appropriator downstream, probably. Now, if there is, the case that someone's been diverting from that spring since 1903, we encourage you to file a claim. Or if you have an appropriated right on that spring, file a claim. And we can look at and see if there's a water right associated with that particular spring. After this meeting, I'll kind of take you through our map interface. It's pretty straightforward, pretty easy to discern if you know where the location of the spring is on an aerial image to identify if there's a water right associated with that or a point of diversion. Did I see? Let me go over here real quick. Yes, ma'am.
The property I have was purchased in early 1953 or 54 when I was a child, and there was a ditch that ran the full length of our street halfway through the depth of the property.
Mm-hmm.
I had almost forgotten that it was there at one point. And somewhere along the way it got covered over. And I don't recall, as a child, I don't recall why that water was all of a sudden gone. However, I was digging one day to try to plant some things, and I hit upon a metal culvert, I guess it is.
Mm-hmm.
There's nothing running through there. But how would I ever know whatever happened to that water?
So,
To be honest with you, most of those neighbors in that street don't have the knowledge of that history there.
yeah.
What do we do to research that?
So her question, there's kind of some background. She explains that she had this historic ditch. The property was purchased back in the 1950s, and there was a ditch that was once crossed her property. Over years, it kind of got covered up, and she's wondering, how do we find out whatever happened to the water that was running through that ditch? Most likely what's happened is that Salt Lake City's acquired whatever rights were once associated with that ditch and used it to provide water, culinary water, to others throughout the valley. That's probably what happened. I don't know for sure. But if you want to know what really happened, the history, Salt Lake City is probably your best chance. Or we do have some old hydrographic survey maps that we can look at if it's really just, you just want to figure it out. But to maybe the implied question is there a water right associated with that? Probably not. Or there is, or there was once a water right, but as you described, it's been fallowed for several years. And even the fact that, just by virtue of the fact that that ditch may have crossed your yard, doesn't necessarily indicate that there was a right to use that on that property, or that any previous predecessor in interest to that property had a water right. So again, if you have we can talk and look at it and see what evidence there is, but that's my swag for you. Yes, sir. Ma'am.
If you had a turnout, because I had an old canal,
Mm-hmm.
and I had turnouts for watering my property. So it was so I could put in a gate
Yeah.
to water. Of course, it all went to the 1200 East Canal, which the city took over. But we don't know, we believe we have water rights.
So you may. Her question is, I used to have a ditch that I had a little turnout, probably a little gate or something that you put it in and it'd spill out onto your property and flood irrigate, right? So there are instances of that in this area. And generally what's happened is that back in the old days, right, they used to divert clean water out of Parley's Canyon or Immigration Canyon and irrigate it on these highlanders' ground. Well, there was a time where Salt Lake City said, well, hey, we really like that water better than we like our Jordan River water. So I'll tell you what, we will provide you Jordan River water if you let us take that water. And there was these kind of contractual agreements, exchanges. I'm not sure if this is part of that or not. Generally what happens when that occurs is Salt Lake City runs the system, or it may have been, hey, we're going to provide you a culinary service. I don't know enough about that area to be able to speak to that case.
Diverted everything into the canal, which used to take the granite from where the cottonwood down to
Okay.
downtown.
Yeah. It's certainly something that, you could look into. But again,
Will those rights show up on your map that way?
they may. but it would be where it was diverted out of. So if it came out of Parley's Creek, it'd be up Parley's Creek. If it came out of Immigration Creek, that's how our map shows things, is where the point of diversion is located. So it wouldn't necessarily show your turnout. It would show.
But it would turn out from the main canal.
Yeah, so it wouldn't. So the point of diversion for the canal is the point. So a point of diversion is where it comes from the natural source. So it has to be a stream or it has to be an aquifer. So a canal doesn't count as a natural source. So any kind of lateral off a canal, we don't track. Okay, but we can look at it. I mean, if it's something that piques your interest and you just want to figure it out, we'll figure it. We'll try to figure it out. I can't say we figure it out, but we'll give it our best shot. Yes, sir. For what reasons would you have a high probability of keeping your water right? If you are beneficially using your water right and it exists in the first place. I mean, I'm not sure. Help me understand your question.
Well, so let's say you're on the unclaimed water rights list and you file an objection and you want to reclaim that water right. How do you assess, what metrics or how do you assess whether or not you're going to grant that water right back to that?
So let's just start off with you file a claim, all right? Whether you fail to file a claim initially or after the list of unclaimed rights filed, you file a claim. How do we know whether your claim is going to be honored or recommended in a proposed determination? We're going to come out. We're going to look at your property. If you have a well and it looks like it's functioning, you have evidence that's been used, pretty high probability it's going to be recognized, you know. So that's a great question. It doesn't matter what it's used for. It does matter what it's used for, but and we're kind of getting a little bit into the weeds of Utah Supreme Court precedent here. But so there was an old court case that said, you know, even if you have a water right for this, but you're using it for some other purposes, that water right is preserved against forfeiture. So, and we often have that where, you know, these water rights were originally appropriated for domestic uses for inside the house. But subsequent to that, Salt Lake City came in, connected them up, and they severed their connection to the well, but still used their well for maybe irrigation. We would still recognize it, but we'd say, hey, it's not being used for the house anymore. It's being used for irrigation, and it needs to have a change application filed on it. It may or may not, but we would recognize the use as much as we could if it's being used for some beneficial purpose. All right, let me move one more slide and then I'll come to you, all right? Because I think I'm getting close. I got 2 more slides and I'm done. And then people who don't want to stay here can go, and then people who want to ask questions can ask questions. All right, issues. Out-of-date title to water rights on our records. So those 31 people, those 31 rights, they may have old owners of record. And so if you believe you are the owner of that water right, you would need to update title to that with us. There's a process called a report of conveyance. Sometimes we abbreviate that, say ROC. We can talk more about that if you have that issue. Location and no proof required water rights. During World War II, there was kind of a run on young men who were qualified engineers who could file a proof. Because under the system of appropriation, you'd appropriate a water right, then the state engineer would say, all right, you've got to file proof that you're using this water right in so many years. And then they'd file a proof with a map and stuff, and it had to be done by an engineer. Well, there was a time where there weren't enough engineers to do that, so they said, all right, we're going to allow people to appropriate small amounts of water and not require a proof, which is great. It allowed people to do appropriate waters without going through the hassle of trying to find an engineer. The problem with that is that those points of diversion were never really confirmed where those locations were. So you had civilians coming in or the public coming in saying, it's right here, and we think this is the surveyed location of it. And then they were never certificated, or they were never proved up by an engineer saying, no, it's actually here. So sometimes these points of diversion, when you look on the map, they may not be where you think they should be. So take those dots on the map with a little bit of a grain of salt, especially if it's a no proof required water right. Okay, our timeline, October, we're going to send out the notice to file claims. Like I said, October 13th is what we're shooting for. You'll have 90 days that initiates that 90-day claim filing period. In January, that claim filing period will conclude, and we'll we'll actually invest. I know it says we'll start investigating water users claims. We'll actually start investigating once we start receiving them. We're not going to wait until that 90-day window expires. In April, we're going to attempt to publish the list of unclaimed rights, hold a public meeting, and then that 90-day objection period for the list will begin in July. That's when that 90-day objection period for the list of unclaimed rights expires. November of 2018, we will hope to publish the proposed determination, hold a public meeting. Again, the 90-day window to object to that proposed determination begins, and then it concludes in February. Here's some of the questions. I think these have been already asked, but we'll go through them. Will I lose my water rights? The answer is, if you're using your water rights in conformance with the records on the file of the state engineer, you don't need to worry about it as long as you file a water user's claim. Individuals without a water right of record, if you're not one of those 31, but you believe you have a water right, say you believe your well was drilled before 1935 or you were diverting out of this stream before 1903, then you need to file a claim, or otherwise you risk being barred from ever asserting that claim in the future. And again, if water right has fallen out of use for 7 or more years, it may be partially or wholly forfeited. What that means, if you appropriated 100 acres of irrigation and for 7 years you've only been irrigating 50 acres, we would forfeit, or the court would forfeit 50 acres of irrigation and just recognize whatever you've been using. If you haven't been using any of it, then the whole thing gets recommended to be disallowed. There's our contact information. This presentation, the slides, as well as the YouTube video will be available on our websites. Hopefully the slides will be uploaded tomorrow. We'll see about the YouTube video link. It sometimes takes some processing. I believe the website is on that piece of paper down at the bottom, in the footer of the letterhead, probably on the first page.
Yeah, water rights.
Yes, waterrights.utah.gov. Yes. Yes, ma'am. So our question is, once you have a legal water right, is there an annual fee? No, there's no annual fee. Once you got it, you're good. You just got to use it. Now, it's different from a share, which you might pay assessments on shares. But again, we're talking water rights, right? That concludes my presentation. So I'm happy to sit here and answer questions all night long. Those of you who don't want to sit around, feel free to leave, and we'll go from there.
Your map out there, does it have the green dots on it?
Yes, the maps out there do have the green dots showing the